For admission.
Ladyship, may I mention? Am I audible, Your Ladyship?
Yes, you're audible.
Yes. The item number 1 and 2, I want a date because the earlier order, we are challenging it in the Supreme Court. It will probably take another 2 weeks. So kindly give me some time after 2-3 weeks.
1 and 2. When do you want?
After 4 weeks?
Mr. Das,
Yes, madam.
you have interim order in your favor.
Yes,
Interim
yes.
relief is operating in his favor. Interim relief is
No problem. I have got an interim order so far as item number 1 and 2, both interim orders are there. So 1, it will continue. 1 will continue. 2 is until further orders. State.
Your Ladyship is muted. Your Ladyship is muted.
No, I think it's not audible properly.
No, it's on. Can you hear?
It is on mute.
No, it's not. I am hearing it, but
It's very faintly being heard.
faintly.
But the symbol is red. Therefore, it's mute.
Yes, yes, right. Can be on a fixed date so that we also know, because we have to come from Gauhati all the way. Today also I came to Dimapur, again I am stuck. Again I am stuck. So can it be on a date which is convenient for the court and for my learned friend?
You can take then October.
12,
Or 22nd.
Yes.
22nd.
22nd Supreme Court is holiday. There's a holiday in the Supreme Court on 22nd. Diwali vacation.
So 27th can be done. 27th. 27th.
27th on
Doesn't
Monday.
matter on 27th.
Monday, 27th.
Very well.
27th.
27th.
But the interim order will continue. I am deeply obliged, my lord. I am deeply obliged.
Grateful.
But there are subsequent events which has taken place that we want to bring notice. Even in spite of the order that has been passed by the court, they have already filed an application for a trial court. And same thing, they have asked for custodial interrogation. I'll bring notice to the court also. Let them file in the Supreme Court. We'll bring also notice to the High Court. I am deeply obliged.
In your Tarsimlal's order, we'll point out. Let him bring.
Yes,
on
we'll bring it. We'll bring it. Soon we will bring it. Soon.
very well.
Yes, yes.
You can bring it very soon. Why soon?
Yeah, very soon. I am deeply obliged. I'm deeply obliged. Yeah,
Yes.
For admission. For orders, item number 3.
Yeah, please, Your Lordship. Lordship, I have instructions to appear on behalf of respondent number 3, Lordship. So if some time may be granted to file my Bagalat Nama, Lordship. 3, Lordship. Yes, Chang, Lordship.
I'm sorry, Your Lordship.
Law is present. Stop. How much time?
A week's time, Lordship.
A week's time.
Lordship.
What about the other respondents?
They are yet to appear, Your Lordship.
Yet to appear, no? Then we'll list it after 2 weeks.
Lordship.
List it after 2 weeks, awaiting
Lordship. Much obliged.
Obliged. Obliged, Lordship.
For orders, item number 4.
Your Lordship, I've been instructed to appear on behalf of respondent number 3, 4, 7, and 8 and 9, Your Lordship. Yes, Your Lordship, and I've received.
I am for respondent number 1.
I'm for the respondent number 10. Donato Yeto. I'm appearing on behalf of Mr. Joshua.
10.
Respondent 10.
Your Lordship, here I have received the necessary instructions. The department, in compliance to the court order dated 24 to 25, yes, Your Lordship, they have submitted all the necessary pension papers and documents to the Accountant General's office, Your Lordship. Who's respondent number 10?
Lordship, I'm for the respondent number 10.
yes, AG.
Yes, Lordship. Recently, respondent number 10, Mr. Frederick, has been transferred. So the new incumbent AG has been posted. So we still need to seek some instructions, Lordship. So if kindly 2 weeks' time may be granted.
Okay. Learned counsel for the petitioner, Mr. Your name?
W. Yakap Konyak, Lordship.
Research present. Stop. Learned counsel Ms. A.I.M.E. appears for respondent number 3, 4, 7, 8, and 9, comma, Mr. N. Angam. The learned copy of the this
17, Your Lordship. 17/7/25, by which the
Director General of Police, by which the Office of the Director General of Police has forwarded the pension papers of the petitioner to the Office of the Accountant General for necessary steps. She has submitted that the direction of this court in WPC 82D of 2022 has been complied with. So at this stage, the Learned Counsel for respondent number 10 / Accountant General submits that a new Accountant General has taken over, and therefore he requires some instructions to be part of this state.
2 weeks' time.
No, Lordship. Much obliged. For orders, item numbers 5 and 6.
Please, Your Lordship. Lordship, I'm appearing through BC, Lordship. Lordship, this Honorable Tribunal by order dated 14/8/25 directed the appellant company to take steps through paper of application upon the respondent number 3. However, we are unable to comply with that, as the law manager of the company has left the company, and they have appointed a newly law manager, so he's not aware of the instant case. So kindly give us some more time
So that means you are yet to take the steps.
to take steps. Yes, upon the respondent number 3. Lordship.
No, I'm for respondent number 1 and 2. Lordship, we have filed our counter affidavit in IA 91.
Just give them a chance for Archie. Otherwise, Archie may not be a necessary part. It's the driver, isn't it? Driver or owner? Owner of, vehicle owner. Archie, vehicle owner.
Lordship, I can't hear you.
Vehicle owner. Archie.
Yes, owner.
Archie, the vehicle owner.
Yes,
Yes,
Lordship.
Respondent number 3 is the owner of the vehicle.
By order dated 14/8/2025, this court had allowed the applicant to take steps by substituted service by publication in 2 local newspapers on the respondent number 3 within a period of 20 days from the date of the order. Stop. Today, when the matter is called, the learned counsel for the applicant submits that. What did you say? A new law manager.
They have appointed a new law manager.
The applicant company has appointed a new law manager, and he also has to be apprised about this order of the court, and therefore the learned counsel for the applicant has sought for some more time to take the steps on respondent number 3 as directed by this court. So accordingly, list the matter. When? How much time?
Kindly, it may be accommodated on the first week of October.
First week of October, we are on holiday. So second,
All right.
7th, list the matter on 7th October in order to enable the applicant to take steps. Learned counsel, Ms. Such and Such, appears for respondent number 1 and
2.
2 and submits that she has already filed her objection. This is IA for condonation, isn't it?
Yes,
Has already
Lordship.
filed her objections. Stop. List on 7th October.
Obliged, Your Lordship.
For hearing, item number 7.
CD is there? On what ground have you come?
Lordship, I have approached this honorable court on 2 grounds. Firstly, the crown of arrest, Lordship. The high
Ground of
standards,
arrest not provided.
it has been provided, but it has not been provided to the satisfaction of the mandate of law. Firstly. Secondly, on the issue of merits, clear violation of section 41 and 42 of the NTPS Act. The arrest has been made by unauthorized, unempowered persons under the law. In order to save time,
1 minute. Yes.
I may be allowed to quickly take my Lord to annexure to page 13. This is the FIR. The accused here was
Page?
page 13, 1-3.
Yes.
He was traveling in a public transport vehicle. To the officer in charge, so-and-so police station, Sumuto FIR. I have the honor to state that today, dated 23/5/2025 at around 12 hours, while conducting routine NAKA MVCB at all Pitucha Checket on National Highway 29 with 78 Battalion CRPF Secu Zapta, one passenger vehicle winger bearing registration number so and so was stopped, and on checking the party recovered suspected opium consignments from the luggages. Safari trolley color black and blue stripes and green trekking bag, and one passenger, namely so and so. Accordingly, the matter was informed to OC Sichu Zipza Police Station for necessary legal action, and the following recovered items: suspected opium wrapped with black tape and copied tobacco container with total weight of 14 point so and so kgs were seized, and the accused persons were arrested in the presence of an independent witnesses. I therefore request your authority to kindly look into the matter and register a case in appropriate section of law. The FIR has been filed by UPC, Unarmed Branch Constable. This is important here. It is clearly stated that when the initial search was made, the OC was not present at the place of occurrence.
And
The information.
No ASI or anybody was.
No. Now, my lord, thereafter, the grounds of arrest at Annexure 5. At Annexure 6, I'm sorry, at page 25. The signature of the accused is found at the bottom of the page. This is in Hindi, I believe. Hindi or Punjabi, I'm not.
Signed in Hindi.
Yes. Now, the entire grounds of arrest, it has been furnished in English, which is a language.
Which he cannot understand.
Yes. And at page 22 of the petition, the arrest court surrender memo, which starts from page 20. Here in the column, the table which is given at the bottom, towards the bottom of the page, the second table, that is. Page 22, my lord. Yes.
Yes.
Here,
Hindi, Punjabi.
yes. Now, my lord is well aware of the low letdown in Purkayasta's case.
Turkmenista, Bihan Kumar.
Yes. So, in order to save time, I may not place those judgments.
Okay. Let me just go through the case diary.
But I would like to place some single bench decisions passed by this honorable court based on Bihan Kumar and Purkayasta's case.
No, even if we don't go by that, even the fact that the seizure was made by a constable.
Yes, my lord.
That alone actually appreciates.
That is not right, Your Ladyship. It is, the accused was arrested by UBSI. If Your Lordship may kindly have the second page of the CD, I've underlined it, highlighted.
What is important is the initial search, my lord. Other officers may have come after the search and seizure was made. And they may have appended a signature as arresting authority, seizing authority. These things happen. But who made the initial search and seizure? That is important.
Initial was by the CRPF.
No,
CRPF
initial-
on duty. No, he was not arrested. He has been
Search.
searched
Yes.
and then informed the concerned police station.
No, that's why it's searched by CRPF.
CRPF, yes. And they informed the
Even
concerned.
CRPF are not authorized.
They didn't arrest him
No, but they made the search.
for inquiry.
Well conducted routine search and search by the 78th Battalion CRPF.
And a representative of police guide from the SETSA.
Guide.
This is
The
in
party
clear
made to
violation
stop-
of the notification issued by the state government.
Unless check-in is done, how can the
It can only be done by a police officer of ASI and above rank. And these days
Yes.
now Assam Rifle is also empowered.
Yes.
So Assam Rifle also rank of ASI and above.
Yes, my lord.
But CRPF and all, they are not empowered.
Yes, that's true. They are not empowered. But as per the CD, it's shown that the arrest was made by UBSI.
He entered the scene only later on.
No, there was a representative from the police also.
Yes.
Yes, it was there.
CRPF. So
Yes.
this police, what rank he was, that is the thing.
The FIR is self-explanatory, my lord.
FIR is
In
just a
CD, they may
complaint.
have improved their case.
No, this cannot be said to be tailored or improved. This is under 161, so that issue.
And I believe when there is conflict between FIR and the CD, the FIR must prevail. Because in CD, there is chances of the prosecution improving their case.
Regarding the
Ground of arrest was made in Hindi. He was made to understand in Hindi, and he has signed the ground of arrest, and at the same time, a copy has been served to him. That was there. And I've been informed by the IO that from the spot itself, they have a VC with the magistrate, and even the magistrate has asked whether that was served, and it was confirmed that it has been served to the accused. So in fact,
is it reflected?
it is not reflected here. But Your Ladyship, may kindly see the ground of arrest and right of the accused person were intimated. That is there in the CD. So there is no violation of 42(2).
But in the CD, it has to be specifically stated that it was explained to him in the language he understood. That part has to
That is there in the ground of arrest. If Your Lordship, Your Ladyship may kindly see the ground of arrest. The above said ground of arrest has been explained to the accused in Hindi, the language which he understands.
page.
I'm sorry, the CD is not paginated, but then I've flagged it if Your Ladyship
No,
may.
you were saying in the grounds
Oh.
of arrest it is there, no?
Yes. So ground of arrest is there as a part of CD. Yes.
Towards the end.
Yes, towards the end, yes.
Ground of arrest must be in writing.
Yes, it was in
Now-
writing and it was served to the accused.
Once we
So,
say
Your
the ground-
Lordship, the Vihar Kumar case doesn't apply here. In that Vihar Kumar's case, if Your Ladyship will see,
Once-
nothing in such form was furnished, and that is why the accused was released
Once it
for
is-
violation of Article 22(1). But the instant case, there is material, there is evidence to show that the copy has been served to the accused.
My lord, my contention is that once it is settled that the grounds of arrest must be in writing,
If
it
you-
automatically follows that the writing must be in a language,
No, it has to be given in writing.
Yes, it
Yes,
was
yes.
given in writing and it was served to the accused
and
also.
it must be furnished to the accused in a language that he understands.
Yes.
Otherwise, if it is served in Chinese, in Sanskrit,
In the grounds of
it's
arrest
pointless.
itself, it says that the above said grounds of arrest has been explained to the accused in Hindi.
Yes.
Yes, yes. But,
And
my
they're
lord,
saying that it was served in.
Yes, yes, that is there. In fact, the petitioner is not disclosing the fact. It's suppressing.
my contention, my lord.
If your
is-
ladyship would see, even that
Yes,
was
no, my lord. My
communicated to the
contention is
wife
simple.
of the accused.
That once it is settled law that the,
No.
No, they are saying that it is given in written.
Yes.
Yes.
So if it is given in written to
then
you.
it must be in Hindi. Now, in a script that I
That's why
understand.
they're saying,
Yes.
they have given in Hindi to you. They're
No.
saying that they have given you in Hindi.
No, no.
It has been explained to him and it.
I
this,
never, I never received, whether that is in the record or not. Because I have applied this grounds of arrest, a copy of this from the trial court.
Because if it is given to you in written, it will be with the accused.
Yes, yes.
It was never furnished to me in Hindi. And when, my lord, the onus is on the, as per Vihan Kumar, paragraph 21, the onus is on the prosecution to prove that it was served to me in Hindi. It is not on me.
On
The
this-
facts, yes.
But
Vihan-
on this itself, you should have written, there has to be a.
Contemporaneous,
something in written
yes.
saying that the Hindi version has been supplied to him, something like that. Otherwise,
That-
how will the court know that it has been
That is
supplied?
true, but,
Because when they are denying.
Yes, but we can't expect the police to have such,
No, they-
yes,
they
slowly we are
shouldn't,
trying to, yes,
they
impart that, those area, yes, yes.
In paragraph
Your ladyship.
21C,
Yes,
21C,
yes.
this is important.
You educate them now.
Yes,
When
yes.
arrested accused
That,
alleges
yes, we will.
non-compliance with the requirement of Article 22(1), the burden will always be on the investigating officer agency to prove compliance with the requirements of Article 22(1).
Your ladyship, we cannot overlook the
Yes.
facts. In Vihar case,
Now, whether that copy is there in the city or not, that is the,
Vihan's case, if your
Important
ladyship
issue.
would see the
And
facts.
when it is given in Hindi or the
Your
language he
ladyship.
understands, give the original to the accused and then photocopy can be kept in. the
Those
CD.
things, yes, yes, we'll have to impart
Yes.
them, yes.
And here also something written saying that it has been given to him in Hindi, something like that.
Yes, yes.
Otherwise,
Your ladyship,
what to do, we'll have to allow the bail, but we'll give some stringent conditions.
your ladyship on technical ground?
Yes, on this only. On technical-
my lord.
Otherwise, for us, in the instant case, the Vihan Kumar's case doesn't, because the facts clearly shows that something has to be,
Explain in Hindi, okay, I understand. That here is written, explain to the accused in Hindi. But written has to be given to him in written. So this in the. case
Written
diary,
was- yes.
The written copy is not there because even if he has the original, how will the court know that it has been given to him? Because otherwise a photocopy has to be kept. Or
Yes.
something written here so that a Hindi version has been given to him and with his signature. So if that is there, then it could have been a compliance.
On similar ground,
Yes.
on 1st of September,
no, facts,
bail has been allowed by this honorable court.
No, each case, actually, the facts.
Yes.
differ
Yes,
from case to
yes.
case.
yes.
This
Condition-
honorable court speaking through Lord Justice Pranjal Das. I have a copy of the,
They're also same. Grounds not provided.
yes. Grounds was provided, but it was provided in Assamese and Bangla. Although, it was provided in English.
In English.
Yes.
Heard Mr. Sentiaman for the accused
extra
himself is the
copy, I see.
petitioner.
I'll check.
Accused
No, no,
himself-
the wife
No,
of the.
the wife,
Yes.
Mr. Sentiaman for the petitioner, who is the wife of the accused, Mr. Mr. Dharam Singh, who has been arrested on, when was he arrested? On
23rd May.
23/5/2025 in connection with Secure Zubza PS case number 3 of 2025 under section 18 small b, clause b of NDPS Act. The petitioner is the wife of the accused, and it is stated that the accused was, and this bail application is being filed on the following grounds, dash number small one. The seizure and arrest of the applicant slash accused was carried out by UBC Peter Penglang, P-E-N-G-L-A-N-G, Penglang, a constable who is admittedly not an officer empowered under the NDPS Act to make seizure and arrest. Stop. It is stated that the legal position is well established that only officers duly empowered under the Act are authorized to exercise powers under Section 41(2) of the NDPS Act. Stop. Number 2. The second ground taken by the petitioner is that the applicant, that the accused was allegedly informed of the grounds of arrest, but he was unable to comprehend the same. You can see it as the communication was not made in a language known to him. Neither English nor the local dialect are known to the accused person, and it is a well-settled principle of law and a fundamental constitutional requirement under Article 22(1) of the Constitution of India that the grounds of arrest must be conveyed clearly and effectively in a language understood by the accused person, by the arrested person. Stop. The Learned Counsel has relied on the case of Vihan Kumar. You just see from your page 7. Vihan Kumar versus State of Haryana and another, reported in 2025 SEC Online SC 269, to support his contention that the communication of the grounds of arrest must be made effectively and in a language that the arrestee understands in order to serve the constitutional mandate under Article 22(1) of the Constitution. Stop. It is submitted that non-fulfillment of this essential requirement vitiates the arrest and renders the subsequent proceedings liable to be quashed. Stop. It is the categorical statement of the applicant herein that the grounds of arrest were not furnished in writing to the accused at the time of arrest in a language which he understood. Stop. In view of the above, Learned Counsel submits that, prays that the alleged accused may be allowed to be released on bail pending investigation and trial of the case. Stop. Learned PP Ms. S. Marine has produced the case diary, and on the basis of the case diary, she has submitted that it was not a constable but an armed branch ABSI, but armed branch sub-inspector
Yes.
who had made the arrest and the seizure. It is submitted that on 23/5/2025, while conducting routine checking at the Old Police Check Gate Petucha by the 78th Battalion CRPF, the seizure was made. Stop. However, along with the CRPF personnel, there was a representative of the police from the Secho Zopsa police station who was an ABSI. So accordingly, it is submitted that the ABSI, being authorized personnel under the NDPS Act, was not was not an unauthorized person to make the seizure or the arrest. Stop. With regard to the service of the grounds of arrest, Learned PP has drawn the attention of this court to the grounds of arrest wherein grounds of arrest at Annexure 6 of the petition, wherein at paragraph number 4, it is stated that the above stated ground of arrest has been explained to the accused in Hindi. Stop. In the arrest memo also, in the column regarding language, comma, it has been entered that the accused knows Punjabi and Hindi. Therefore, the fact that the grounds of arrest has been explained to the accused in Hindi fulfills the mandatory provisions, fulfills the mandate of Article 22(1) of the Constitution of India. So, accordingly, Learned PP submits that the present bail application may be rejected as none of the grounds set forth by the petitioner slash applicant has been proved. So, this court has considered the submissions of the learned counsels and has perused the CD which has been produced by the Learned PP. So, I'm going through the CD. It is seen that the seizure, the checking and frisking was initially done by the CRPF personnel who are not authorized under the NDPS Act. So, however, along with the CRPF personnel, there was a police guide from the Sechu Zupsa police station who was an ABSI. So, accordingly, it cannot be said that the ABSI is an unauthorized personnel. So, while coming to the grounds of arrest, no doubt the grounds of arrest state that it has been explained to the accused in Hindi language. Stop. However, there is nothing to show on record that the ground of arrest was supplied to the accused in Hindi. Stop. The Learned PP has argued that a copy of the grounds of arrest in Hindi was served upon the accused person, upon the arrested accused person. However, no such acknowledgement or proof, no such acknowledgement or copy is appended in the case diary, and therefore it cannot be said that the grounds of arrest in written in the Hindi language has been supplied to the accused arrested person. The underlying philosophy behind the law laid down by the Honorable Apex Court in the case of Vihan Kumar Supra is that the Constitution requires the accused to be properly informed of the grounds of arrest so that he has a clear idea about why his liberty has been curtailed. So, it is also necessary to enable him to prepare his defense. And the importance of compliance with Article 21 of the 21 and 22 of the Constitution of India rest on a higher pedestal than the statutory restrictions on bail. So, in view of the observations made herein above, this court is of the view that there has been a violation of the provisions and the mandate of Article 22 of the Constitution of India, and for the above reason, the accused Shri such as Dharam Singh, accused Dharam Singh is allowed to go
Yes,
on
Dharam
bail.
Singh.
Yeah, is allowed to go on bail on the following conditions, under the following conditions dash small one. Execution of a bail bond of rupees 50,000 with one surety of like amount, who shall be a local resident of Kohima. Stop. Number two, the accused shall cooperate with the investigating agency, and he shall not try to influence or tamper with the evidence. Stop. He shall
Surrender his travel documents, if any. He should not leave the jurisdiction of the court without the permission of the concerned
he shall
IO
not
and
leave the
court concerned.
jurisdiction of the trial court without the permission of the court. I'll say without the permission of the court.
Court
So
as well as the
if he has
IO.
to go, then he has to apply to the court.
Yes.
Okay.
My lord.
Without the permission of the court, that will do, because the court will obviously ask the IO when the petition is filed. The accused shall not leave the jurisdiction of the trial court without the permission of the court. Yes. With the above conditions, the petition stands disposed. In case any of the above conditions are violated, the prosecution shall be at liberty to move an application for cancellation / revocation of the bail so granted. Yes.
Deeply obliged. If my lord can make some accommodation so that I will be able to get the CTC today.
Yes, of course.
My lord.
It will be done today itself.
Deeply obliged.